So today we are going to start our fourth and last session of our ongoing playlist, which is laws related to real estate. In today's session we are going to cover Rent Control Act, rights of tenants, landlords, lacunas of Rent Control Act. We will also cover licenses, leases, and we will also touch upon the inheritance and succession laws. So this is the full syllabus as per IBBI exam, which is being covered into this chapter. Land Acquisition Act already covered in session number 1. Then Transfer Property Act has already been covered in session number 2. RERA Act has been covered in session number 3, and remaining part we are going to cover in today's session. So let us first start with rent control laws or Rent Control Act. The concept of rent was originally established under TP Act, Transfer of Property Act. So post-independence, to protect tenants from exploitation and ejectment or eviction, Rent Control Acts were introduced, superseding Transfer of Property Act. So TP Act was before independence. So earlier rent was explained and tenant was explained into TP Act. So during independence, a lot of landlord asked their tenants to evict their houses, basically. So to protect the tenants under previous TP Act, new Rent Control Acts were enacted by all the state governments. So Rent Control Act falls within purview of state. So different states have different Rent Control Acts. So, but from examination perspective, we'll try to cover major points of which are common for all the Rent Control Acts. Since housing is a state subject, enactment and enforcement of rent control laws is responsibility of individual states. So please note down this bullet point. The Act provides protection to rights of both landlord and tenants. Under Rent Control Act, courts decides the rent of land or land plus building premises, and the said rent is called standard rent. Please note down this bullet point also, definition of standard rent. This we have also covered in earlier session also. So landlord cannot charge rent more than standard rent. So as per Rent Control Act, no landlord, if any property is falling under Rent Control Act, landlord cannot charge any rent more than the standard rent. So this concept we may be required to apply while doing valuation using income approach also. So many a times examiner may make some tricky case studies, tricky numericals or case studies by putting rent control clause, and we have already discussed one type of case study into our previous playlist on income approach to valuation, wherein we had studied how to calculate valuation of property on which Rent Control Act is applicable. So as we have studied that Rent Control Acts are a state subject. However, there are some common guidelines among majority of these Rent Control Act of each state. So properties belonging to government are exempt from the act. So be it any state, any Rent Control Act, so any property which belong to the government are exempt from this act. Any tenancy created by a grant from the government or property taken on lease by government are exempted. Properties let out to private limited companies or public limited companies with a paid up share capital of 1 lakh rupees or above are exempted. Properties let out or sublet out to PSUs, banks or any corporation established under any state or central act are exempted. Please note down these exemptions. 1 mark theory question may come, and these concepts you may require to remember these concepts while solving the case study also. Examiner may try to confuse you by putting information about the standard rent and Rent Control Act, and that then you have to see whether Rent Control Act is applicable on the property or not. If it is applicable, then you have to do valuation considering application of Rent Control Act. If it is not applicable, then you have to calculate valuation of property through using income approach, following the market rent of the property, not standard rent. Then property let out to foreign companies, international missions and international agencies are also exempted. Newly constructed properties up to certain period from date of construction are exempted. Please note on this bullet point. So this period vary from state to state. For example, in Delhi it is 10 years. So new constructions, new buildings are normally not covered into are exempted from Rent Control Act. Any premises, residential or other, whose monthly rent exceeds beyond certain amount are exempted. So it also varies from state to state. For Delhi it was 3,500 rupees. Lease agreement for a period less than 12 months are exempted. The agreement through which a property is given on 11-month lease is called leave and license agreement in India. That this is the reason, that is why people normally give their property on rent only for 11 months. So that Rent Control Act shall remain exempted. The property shall remain exempted from Rent Control Act. As a rental agreement that is 11 months long is just a license for tenant to occupy the premises for short duration. So this is also important bullet point. Rights of tenant as per Rent Control Act. Important rights which are being provided to the tenants are as under. So first right is right against unfair eviction. So if Rent Control Act has been made applicable on the property, then tenants will enjoy certain rights. First right is right against unfair eviction. Under this act, the landlord cannot evict the tenant without sufficient reason or cause. The rules of eviction are slightly different from state to state. In some states, for the landlord to evict a tenant, he or she must approach the court and obtain a court order for the same. So before in few states, without a court intervention, landlord cannot ask the tenant to evict the house. In some states, the tenant cannot be evicted if he or she is willing to accept any changes to the rent. So these guidelines different and vary from state to state. Fair rent. The landlord cannot charge extraordinary amount of rent. Normally maximum rent that can be charged is dependent on the property value. Usually the rent is to be between 8% to 10% of the value of the property, including all cost of construction, fixture, etc. So value of property means including cost of construction all along with furniture, fixture, etc. If tenant feels that the amount of rent asked is very high as compared to value of property, he may approach to court to seek redressal also. Essential services. Even if tenant fails to pay rent, the tenant has right to enjoy essential service like water supply, electricity. So if I have given a property on rent to a tenant and Rent Control Act is applicable on that property, and say my tenant is not paying me rent, so I cannot cut water supply, electricity of the tenant as per Rent Control Act. There are also certain rights which are being given to the landlord. So landlord is a person who for the time being is receiving or is entitled to service the rent of the property. The property can be of his own or in other name, but taking rent as a trustee, guardian or court receiver or on behalf of another. So basically you should know what is the definition of landlord as per Rent Control Act. So this is the definition. So there are certain major rights which are being enjoyed by the landlords. First is right to evict. Majority of these acts give this right to evict tenant who is guilty of certain specified acts as under. So if tenant is guilty of any of the following acts, the landlord can ask the tenant to evict the house. Breach of condition of tenancy, subletting without authority or permission, default in payment of rent for specified period, material deterioration in the condition of the building. So in majority of state acts, landlord can also evict a tenant if the landlord requires the house for his own personal occupation, exception Karnataka. The landlord, after sending sufficient notice to tenant, need to approach the court to evict the tenant. Please note on this bullet point, 1 mark theory question had come during my exam also. So if landlord wants to use this house for his own personal occupation, then he can ask to evict the house, but this rule is not applicable in Karnataka. So examiner may put this theory question in a twisting way also, and case study may also be giving location about Karnataka or Bangalore. So please remember all these points. Rights of landlord. So charge rent, that is also another right of landlord. So landlord has right to charge rent upon tenant. So he has right to take rent from the tenant. As such, there is no legislation for providing upper limit on the rent. However, as a matter of practice, it doesn't exceed 8 to 10% of the property value. So different states have different guidelines regarding concept of freezing of rent. So this is also an important terminology, freezing of rent. Normally, actual increase in rent doesn't exceed 5 to 8%. So this is the normal cap. So beyond 5 to 8%, annual increase is not permissible. So that is kind of freezing of rent. So that is also given in the provision is given in the Rent Act. Temporary repossession of property. The landlord may temporarily repossess the property to improve the condition of the property, alter the property in any way, or make changes to the property. So if I have given a property to a tenant for rent purpose, so if I am not able to evict that property, ask the tenant to evict the property, even if I can ask the tenant to please go out of the property for certain time, and I want to do some additional painting or some additional construction or repair renovation, so that I can do. But such changes to the property must not bring any loss to the tenant or any materially affect to his tenancy. So I cannot demolish the structure and construct a factory over there, right? I cannot demolish all rooms and I can make a single hall, so that my tenant cannot stay there. So those type of material changes cannot be made, but yes, changes which doesn't affect tenancy or utility of the property for tenant, those changes can be made by the landlord. There are certain lacunas of Rent Control Act. So the act in majority of states is pro-tenant, and thus it is difficult to evict tenants. There is a first major lacuna with Rent Control Act. Then fair rent is being fixed by controller as per Tenancy Act of State. That is another second concern or issue with Rent Control Acts. There is an obligation on landlord to issue rent receipt. However, all landlord doesn't issue rent receipts. Property tax is being calculated on percentage of annual rentable value of the property. So next topic is Licenses and Easement Act. So section 52 of Easement Act defines a license given by one person to another person or a definite number of other persons. So one person can give license to one person, or a definite, it cannot be given to indefinite number of persons. The license gives other person or persons, definite number of persons, a right to do or continue to do following in or upon the movable property of the grantor who gives license. He can move in and out of the movable property of the something which would in absence of such right be unlawful. So I can do something which if I have not given license, so I cannot do, and if I do in absence of license, that remain unlawful, and such right doesn't amount to an easement or an interest in the property. So this license doesn't give me any type of easement or interest in the property. I do not get any type of ownership, but I get certain rights to use that property. And if I do not get, if I use that property without taking this license, then that usage is unlawful. For example, I want to see a property. If I'm looking at your house, so I need not to take any license for that thing. That is not unlawful. But if I want to organize a 2-hour party or evening party in your house, marriage party in your house lawn, so I need to take some permission from you. And without taking permission, if I organize a party in your house, it is unlawful. So that is a license. So this right is called license. So please note down definition of license. 1 mark theory question may come. Then there are certain important characteristics of a license which are relevant from examination perspective. So we'll try to cover these important characteristics in 1 or 2 slides. So license is a bare permission and is without any transfer of interest in the property. Each and every bullet point can come in the form of 1 mark theory question in the exam. So please note down all these bullet points. So license is a bare permission. Please note down these 2 keywords, and is without any transfer of interest in the property. License is neither transferable nor heritable. License is neither transferable nor heritable. Licensee or holder cannot transfer his right through sublicense. I cannot transfer it further. In case of death of licensee, his rights do not get transferred to legal heirs. So if I have a license and I die, then my rights will not get automatically be transferred to my legal heirs. The license is a personal contract between grantor and licensee. Thus, the license comes to an end with the death of either the grantor or the licensee. So the person who has given the license and person who has accepted the license, if either of the two persons dies, license gets automatically cancelled. It comes to an end. License creates no duties and obligation upon the grantor. So if I have given a license, I am landlord, I have given a license, so there are no duties or obligation on me. Thus, license can be withdrawn at any time at the pleasure of grantor. So here landlord get more rights. In case of Rent Control Act, tenant was more powerful, but in case of this license concept, landlord feels more powerful. There are no duties or obligation on him. He can anytime take back that license. In case of sale of property to a third party, licenses associated to the property automatically comes to an end. No separate termination is required. This is a very important point because in case of valuation of property, this may come. So if I sell a property which falls into Rent Control Act, then valuation of property will be done considering standard rent. But if a property is being given on rent under license, then valuation of property will be done using income approach following the market rent, not standard rent. Licensee cannot defend his possession in his own name as he doesn't have any proprietary right in the property. Thus, licensee cannot sue trespassers and strangers in his own name. Grantor of license must be the owner and licensee must be a stranger or have no right to the property. So owner cannot give a license to himself. So the person whom license has been given, he should be a stranger and have no right in the property. He should not have any ownership right in the property. There is no requirement of consideration, material or non-material, required between grantor and license to create a license. So there is no requirement that there should be some exchange of money. It is not a must requirement. Normally it used to have. So license is revocable, can be cancelled. This is also important bullet point. Please note down. So third important section of the today's session is, third and last session is inheritance and succession laws. This is also very important from theory perspective. 1 mark theory or 2 mark theory may come out of this session. Very easy to understand and interesting also. Indian Succession Act 1925 came into force with effect from 30 September 1925. Please note down this bullet point. It seeks to consolidate all Indian laws relating to succession. As per the Act, succession means capable of comprehending every kind of passing property. That is, the right and transmission of rights and obligation of the deceased to his heirs. Please note down this definition of succession. The Act can be broadly divided into two parts: testamentary succession and in-state succession. So testamentary succession is applicable when a written will has been created, and in-state succession is applicable when will has not been created. So succession can be done through verbal thing or also through written will. So if written will is created, then testamentary succession of the Indian Succession Act will be applicable, and if no will is written, then in-state succession part of the Succession Act will remain applicable on the transaction. So please note down these two bullet point also. Sometimes 1 mark theory question also come from this bullet point also. So this is a very simplified form. All the acts and validity has been reproduced for easy and convenience remembrance of these things, because people normally get very confused. So this is a very simple table. If you remember, if you just understand this table, you will be able to understand which law is applicable on which community. So when a person dies, applicability to community, different communities, different laws are applicable. So when a person dies without making a will, valid will, and if he is a Hindu, Jain, Sikh or Buddhist, then Hindu Succession Act will remain applicable. Please remember all these, any number of any type of questions can come out of this slide. So after death of a person, if he has not written a will, so first of all, when any theory question will come and any case study will come, then you have to see that the person who died, whether he has written the will or not written the will. So if he has died without writing a will, then focus on this table only. Then these three laws will remain applicable. And if that person is Hindu, Jain, Sikh or Buddhist, then Hindu Succession Act will be applicable. If the person who died without a written will is Christian, Parsi or Jew, then Indian Succession Act will be applicable. And if he is a Muslim, then Muslim law, Shariat law will remain applicable. However, if the person who died had written a valid will, he had made a will. So it is simple in this case. If the person who died was a Muslim, then it is a Muslim law which will be applicable on the will, and in all other cases it will remain Indian Succession Act. So just to simplify, in case of Muslims, always Muslim law or Shariat law will remain applicable, whether he has written the will or not written the will, right? But in case of other communities, in case of all other communities, if written will is given, then Indian Succession Act will remain applicable. However, if written will is not given, then for these four communities, Hindu, Jain, Sikh and Buddhist, instead of Indian Succession Act, Hindu Succession Act will remain applicable. What is will? It means legal declaration of the intention of the testator. Who is testator? Maker of will, with respect to his property which he desires to be carried out into effect after his death. So if I own some property, I want to make a will, so I am a testator. The document which I have created for distribution of my wealth, distribution of my property, my estate, it could be property, it could be FD, bank balance, anything. So that legal document is legal declaration rather. So it could be written document or verbal also. So it is legal declaration. So that legal declaration is called will. Following are the main characteristics of a will. Legal declaration by a maker, it has to be. It relates to his property. I cannot make a will for other property. It must take effect only after death of maker. So if I have prepared a will, so it will come into force or effect after my death only. It must be revocable during the life of time of the maker. At the time of revocation, the maker should be competent to dispose of his property. So if I have made a will, I can revoke it during my lifetime. Who can make a will? Every person who is major and has a sound mind. So these two important terms are there. May dispose of his property by will. Following persons cannot make a will. Minors cannot make a will. Lunatics, persons mentally ill, and intoxicated person affected by alcohol or drug. If I have taken drug, consumed a drug, and during under impact of the drug, I cannot make a will. The different types of wills which are relevant for our examination purpose. First type of will is privileged wills. A will executed by any soldier, airman, mariner employed in the expedition engaged in warfare who completed 18 plus years of age. Unprivileged will, it will be executed by anyone else except mentioned in privileged will. So this is privileged will. Any will which is executed by any other person and doesn't fall into privileged will is called unprivileged will. So this is first type of categorization. Then contingent or conditional wills. Execution of these wills are dependent on happening of an event and if that event occurs in the future, only then the will is to be considered to become effective. Joint wills, when two or more people agree to make a co-joint will. These are generally between married couples with an intention to leave the property to their spouse after one of them dies. Basically, I and my wife sign a will in the name of each other. So if any one of us dies, then other person will become absolute owner of the property. Mutual wills. So there is a difference, slight difference between mutual will and joint will. Please note down this thing. When two people agree to formulate a will on the mutual agreed terms and condition, these are common among married couples. So joint will was also common. It helps to ensure that property passes on to the children of the deceased and not to a new spouse of the surviving partner in case they remarry. So in case of joint will, husband and wife sign a will, and in case of death of one partner, the entire property gets transferred to the other partner. The purpose of joint will is that. But in case of mutual will, the purpose is to smoothly transfer the property to the kids. So in case the other partner gets remarried, then the new partner will not get any share in that property. Instead, children from the first marriage of the deceased person, right? So those children will get the property. So that is a slight difference between joint will and mutual will, and please note down this 1 mark 3 question may come out of it. Duplicate wills, if two copies of a same will are created, it is called duplicate will. Generally one copy is kept with testator and other copy is kept with bank locker. Holographic will, this is also important 1 mark 3 question. So wills which are handwritten by testator himself are called holographic will. Being handwritten, these wills have been strong presumption pertaining to their regularity and execution. Concurrent wills. Normally a testator makes single will for all properties. However, if testator wish to make different wills for different properties at different geographical locations, so these coexisting wills are called as concurrent wills. Sham wills. So in case of concurrent will, if I have multiple property in different locations, one property Delhi, Mumbai, Chennai, and I make different wills for all these properties, so all these wills executed at the same time are called as concurrent wills. Sham wills, this is also important type of will. Theory question, 1 mark 3 question may come. These wills are created for an ulterior motive, hidden intention, which is neither testamentary operation nor execution of will. Rather, in most of these cases, these wills are created for an immoral purpose, like acquiring a property that doesn't belong to the claimant, deceiving someone, etc. So kind of fraudulent will. Executor of a will. An executor is the person who disposes of or oversees the settlement of the assets of the deceased person in accordance with the wishes of the deceased testator as given in the will. So after my death, the person who will execute my will is known as, or the person who will dispose of my assets as per terms conditions mentioned to my will, that person is called as executor. So name of the executor remain mentioned in the will or codicil. We'll see what is codicil in next slide, but it remain mentioned. So as a part of will, name of the person who will execute my will remain mentioned, and that person is called executor. In case no executor is mentioned in the will or its codicil, competent court grants a letter of administration to an administrator to administer the estate of the deceased in accordance with the will. So normally it remains mentioned in the will or codicil. However, if the will or codicil remains silent on the name of executor, then letter of administration is being given by the competent court. So next is execution of will. On death of the testator, an executor of the will or an heir of the deceased testator can apply for a probate. So we'll see what is probate in next slide. The court will ask the other heirs of the deceased if they have any objection to the will. So if after my death, the executor or heirs of the deceased, my legal heir, will approach to the court along with a copy of will, and they will seek a probate. Probate is a legal document which normally court provides. It's a kind of stamp document given by the court certifying the will. So before giving the probate, the court will ask other legal heir of the deceased person also, and they will seek their objections if they have any. If there are no objection raised, then the court grants probate basically. So what is probate? Probate is a copy of a will certified by court. So that will be certified by the court after seeking no objection from the all legal heirs. It is to be treated as conclusive evidence of the genuineness of the will. So once the probate probate has been issued by the court, the will is presumed to be genuine, because a person may write multiple wills also. So the will on which probate is given by the court is presumed to be the final will. Codicil, it is an addition or supplement that explains, modifies or revokes a will or part of the one. So after making a will, I can make certain adjustments or amendments into will by there is an additional document which is being attached to the will, and it enables the testator to add some information or modify some information, make some amendments in the will. So that additional document is called codicil. 1 mark 3 question may also come on this slide also. Registration of will. A will is required to be registered with registrar or sub-registrar with a nominal registration fee. A will or codicil doesn't require to be stamped at all. There is no requirement of stamp, but registration is required. The testator must be alive and present in the registrar office along with 2 witnesses for registration. So normally 1 mark 3 question may come that whether stamp is required, whether registration is required, whether 2 witnesses are required, 1 witness is required, whether a testator is required to be present in the registrar office. So normally people feel that since registration is required, so stamp are also required. But here only registration is required along with 2 stamps and physical presence of the testator in the court or registrar office. However, there is no requirement of putting any stamp on the will for registration purpose. Revocability. As per section 62 of Indian Succession Act, a will can be revoked or altered any time during lifetime of testator. However, a mere intention to revoke is not an effective revocation. So I have shown intent to revoke the will, that is not revocation. The revocation of will should be in writing, and an express revocation clause would revoke all prior wills and codicils. The revocation can be done via cancellation of will by executing deed of revocation to be signed by testator and 2 witnesses. So I can cancel my all previous wills and codicil by creating a new document which is called deed of revocation, and it has to be signed by me along with 2 witnesses. Subsequent marriage of the testator. If I get married after making a will, then it gets automatically cancelled. Subsequent will or codicil, if I make another will or codicil without mentioning the previous will, so it will also revoke. Instrument of revocation and destruction of will, if I tear it off or damage it off. So that's all in today's session. Thank you very much for watching today's session and ongoing playlist. So before I'm going to tell you what we are going to have in our next playlist, I would again request you to please subscribe to the channel, click on bell icon. So this is very important and interesting and scoring topic which we are going to cover in next session, next 1 or 2 sessions. So we are going to discuss about important case laws. So people find it very hard to understand these case studies, to remember these case studies, what was there in these cases. But if I'll try to give you some simple tools, tricks, and simple tricks to remember these case studies, what was there in these cases. So there are these 10 case studies as per IBBI syllabus. However, there are 5 more additional important case studies. Normally, sometimes theory question may come in the numerical in the IBBI exam. So put together, we will discuss 15 case studies in upcoming 1 or 2 session on important case laws and principle of valuation of real estate. Thank you.